I'm Jamil John A. Malaga from N30. Chapter 4, Activity 4. Number 1. How the court acquires jurisdiction over the person of the accused. The court acquires jurisdiction over the person of the accused upon voluntary submission of the person of the accused to the jurisdiction of court. 2. By posting of bail. Or 3. By arrest of the accused. Number 2. What are the forms or kinds of bail? A. Cash bail. Cash bail is a sum of money in the amount of designated in an order fixing bail posted by the accused or by another person of his behalf with the court of other authorized public officer upon that such money shall be fortified if the accused does not comply with the directive of the court requiring his attendance at the criminal action or proceeding involved and does not otherwise render himself. Letter B. Corporate surety issued by professional bondsman, that is one who habitually engaged in the business of furnishing bonds in civil actions. C. Um, um, Recognizance is a contract between the sureties and the state for the production of the principal at the required time. Letter D. Property bond is an undertaking constituted as a line on the real property given as security for the amount of the bail. Number 3. When bail is a matter of right. Before or after conviction by the Metropolitan Trial Court or Municipal Trial Court or the Municipal Trial Circuit in cities or Municipal Circuit Trial Court. Letter B. Before conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or the life imprisonment. Number 4. When bail is a matter of discretion. Bail is a matter of discretion upon conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment. Admission to bail is discretionary. Number 5. What are the place where bail may be filed? Bail in the amount fixed may be filed with the court where the case is pending or in the absence or unavailability for the judge thereof with any regional trial judge or metropolitan trial judge. Letter B. Where the grant of bail is a matter of discretion or the accused seeks to be released or recognizance, the application may only be filed in the court where the case is pending, whether on the preliminary investigation trial or appeal. When warrant of arrest may issue. Warrant of arrest may issue by the regional trial court within 10 days from the filing of the complaint or information. The judge shall personally evaluate the resolution of the prosecutor and its supporting evidence. B. By the municipal trial court when required pursuant the second paragraph of section of this rule. The preliminary investigation of cases falling under the original jurisdiction of Metropolitan Trial Court or the Municipal Trial Court. C. When warrant of arrest not necessary. A warrant of arrest shall not issue if the accused is already under detention. Pursuant to a warrant issued by the Municipal Trial Court in accordance with the paragraph B of this section, or if the complaint or information was filed pursuant to Section 7 of this rule. Number 7. What are the remedies after the court acquires jurisdiction? First, or A, quasal of information. B, assailing the validity of the warrant of arrest issued against him. Letter C, assailing or questioning the regularity or absence of preliminary investigation. And D, quasal of the search warrant, suppression of evidence obtained. And letter E, suspension of proceeding by reason of prejudicial question. And letter F, motion for bill of particulars. And letter G, motion for production and inspection of material, evidence in possession of prosecution.